Technology, know-how, patents, and other intellectual property are commodities that can be bought, sold, leased, or shared. Sales, licenses, franchises, and joint ventures such as co-promotion, co-marketing, co-development, those sorts of arrangements are some of the mechanisms for buying, selling, and leasing technology, know-how, trade secrets, and other types of intellectual property. So the types of licenses, types of rights that can be granted or received through a license in the context of the different categories of intellectual property that we typically encounter are the following. So a patent owner has the exclusive right to make, use, sell, offer for sale, or import the product. It can license some or all of those rights, and the licensee can receive some or all of those rights. Similar, a process patent, use the process to make a specified product, etc. Copyright, we're typically talking about the right to use, reproduce, translate, modify, publish, sell copies. Trade secrets, know-how, use the technology for a specific purpose. Industrial designs, make, import for trade, sell, rent, or offer, etc. And trademarks, finally, the right to use the mark to distinguish a trader's wares or services from those of others. So those are the sort of general categories of protected rights that can be subject to a license arrangement. So the use of licensing in business. Firms expand and increase business by acquiring new technology under license or by licensing their own technology to others to expand market reach. Managers of small and medium-sized businesses have found additional profitability by incorporating licenses into their business programs by either licensing in to obtain a new product, new design, new process, or licensing out to sell a technology to others for increased profits through royalty. Deciding on the whether, why, and when. I'm going to spend a few moments discussing the advantages of licensing to a licensor. Some of these are stating the obvious, some of them may not be so much so. Increased income with little or no capital investment. So if you give a license to somebody else who's prepared to manufacture and sell and do all the work, and you sit back and collect a comparatively smaller royalty, then that is one clear advantage. New uses of technology by others. So you may have a valuable patent and you're practicing it in a specific area. There may be all kinds of other uses or markets for your invention that you could license to others who are willing to practice in those areas where you may not otherwise be prepared to. The last bullet is a variation on the same theme, use of technology that's not being used by the licensor. You may have a bunch of stuff that you're not using at all. Also, you can avoid certain legal problems, again stating the obvious. Instead of suing an infringer, set up a license. Again, that's an economical solution to patent infringement. A number of different business models are entirely centered around infringement. The so-called patent trolls who acquire patents, hold patents, and do nothing other than look for infringers and pry royalties or threaten to sue. Patent trolls, some of you, it has a negative connotation. The negative connotation is because the patent trolls, they're viewed negatively because they really don't do anything other than that activity. They don't have any independent business. They're not creating products. They're not innovating. They're not selling. They're not actually manufacturing or producing anything. But it's otherwise legitimate practice. Advantages to the licensee, expanded rights, obviously by receiving new products, new technology, and R&D. Expanded assistance from the licensor by way of technical and commercial assistance. Expanded marketing and sales. One example from the pharmaceutical industry, a lot of smaller pharmaceutical biotech companies exploit products originally created by big pharma when those products are unsuited to the larger firm's market or production scheme. For example, a small firm may seek to license relatively small volume, highly specialized drugs from larger firms that find profitability in larger volume production, so they're not particularly interested in commercializing the smaller product. Expanded profits may be less expensive to license in new technology or products than it is to develop them in-house. That's That's an important, self-evident but important consideration. It doesn't make sense for you to sit there and grind away with developers coming up with something that's already in existence. It might be more economically beneficial to secure a license. And again, the flip side of what I mentioned earlier, you can avoid conflict or infringement suits. If you're found to infringe somebody else's patent, seek a license. Licensing both ways at once, or cross-licensing. I've got a little summary at the bottom of the slide. Cross-licensing is the mutual exchange of technology between two firms on a licensed basis. Concept offers an opportunity for a company to exchange the use of its own technology for the advantages of another's development. Each firm thus has a new technology for process or product improvement. At the same time, a minimum amount of money changes hands because the technology evaluations tend to compensate each other. There are also synergies in working together with another partner in the same space by sharing information and staying in touch with what's going on in the industry. Being plugged into the technical gossip and other information, what's going on in the industry, which is critical. A few words about some of the other technology agreements that I alluded to earlier. Co-promotion agreements. These are agreements where typically one company has the technology, may not have the resources, the marketing expertise, the sales force, the distribution channels to actually commercialize the product. It might pair up with a larger company, and it's complementary to both parties in that way. Co-marketing agreements, similar, slightly different from co-promotion agreements, similar kind of concept. An example of co-marketing would be IBM and Microsoft with DOS together in their products. Another example could be video game manufacturers with game card producers. Cases where there are synergies and the products are complementary to each other. Another important type of joint venture, licensing joint venture, is for the co-development of technology. This is a fairly common arrangement. Parties have good ideas, they're operating in similar spaces, and they say, why don't we get our people together and let's see what we can come up with, put our heads together and see what pops out at the end of the day. Now, in discussing co-development agreements, I wanted to spend a few minutes discussing some of the problems that we have seen and that arise through co-development agreements and the intellectual property that arises pursuant to that sort of an arrangement. So the issue is, what happens to the arising technology? Which parties, which rights do the parties have in whatever comes out? This issue is often very difficult to resolve in the contract negotiation stage, and we have seen time after time after the fact where the parties have agreed that any IP that's created will be, quote, jointly owned or co-owned. And there are some pitfalls from a legal perspective on that type of approach. Again, the issue should be resolved in writing in advance and direct what the respective rights and obligations of the parties are up front. That often doesn't happen, as I just mentioned. Under Canadian law, in the context of patent law, if parties co-own a patent, each party has the right to assign his or her interest in the patent without consent of the other co-owners. They also have the right to make, use, and sell without accounting to the other co-owners. But the co-owner can only license the patent with the consent of all other co-owners. And if you think about it, that makes sense. If you enter into a joint development arrangement, you each have an equal interest in a patent that arises, yet your partner goes off and starts issuing non-exclusive licenses all over the world, it's going to undermine the commercial value of your 50% interest in that patent. So that's a good result under Canadian law. In the US, it's slightly different. In the absence of any agreement to the contrary, each joint owner may make, use, offer to sell, or sell the patented invention without the consent of and without accounting to the owners. There's no fiduciary relationship between patent co-owners, so the co-owners are effectively at the mercy of each other.